Placing a child in imminent danger of physical and mental impairment by having child in an environment with access to illegal substances. PR counsel. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility. Court is calling 2025 CR 007562B and 2025 CR 009816 State versus Kelly Aguero. Could I have parties announced?
Jason Garrett here for the state, Your Honor. Amber here for the state as well.
We need Scott for the defense.
All right. So off the record for a moment. So they don't have the W to signify waiver numbers anymore?
The clerk informed me at the last setting we did this, but they won't be there.
Okay.
Unfortunately.
All right, just so I can know where we are. All right, we're back on the record. And cause number ending in 16, did you review the document entitled Waiver of Indictment, Reading of Information and Rights under Article 1.05 and 26.03 of the Code of Criminal Procedure?
Yes, ma'am.
And did you understand that?
Yes, ma'am.
Do you understand you have a right to have a grand jury hear the evidence in this case and make a decision on whether or not to hold you over for trial? Your attorney has certain rights. Also, the right for the passage of 2 days once he's presented with the information and 10 days to prepare for trial. Did you understand?
Yes, ma'am.
By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
In that cause number, the court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Counsel, in each of these cause numbers, have you received all discovery and did you review it with your client?
Yes, sir.
In each cause number, the court will find that the state is in compliance with discovery. Miss, in each cause number, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Did you review the court admonishments in each of these, state?
Yes, Your
Um, just one moment. I'm just trying to find a document. All right, we're off the record. Defense, did you all get a copy of the information?
Yes, sir. I think
All right,
Gave
King
it
Clerk,
to
so
the
I don't have a
clerk.
copy of the information.
She stepped out, Judge.
well, I don't think this is the original. I thought I gave them the
Let's
copy.
see that and I'll hand it back
Yes,
to
ma'am.
you. All right, we're back on the record. Did you review the information in the cause number ending in 16 with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the information?
Yes, Your Honor.
And state you're proceeding on the information as presented?
Yes, Your Honor.
All right, and then in cause number ending in 62B, did you review the indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No objection.
And each of the cause numbers, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, and the cause number ending in 16, you're charged with placing a child in imminent danger of physical and mental impairment by having child in an environment with access to illegal substances. PR counsel. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility. If the court were to grant your application for deferred adjudication in that cause number, if for any reason your deferred adjudication were revoked, the court can find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine. And the cause number ending in 62B, you're charged with possession of a controlled substance penalty group 2, 4 to 400 grams as a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison with up to a $10,000 fine. If for any reason the court were to grant your application for deferred adjudication, if for any reason that deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes.
And each cause number, if you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, The fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. By entering into this pleas, you're giving up those rights. Did you intend to give up those rights and enter into plea bargain agreements in each of these cause numbers?
Yes.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Aguirre, on each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No,
Anyone promised you anything other than the plea?
no,
Are you satisfied with the way you've been represented?
yes, ma'am.
Did you understand if you're not a United States citizen, then you could be deported, denied naturalization, and not allowed re-entry into the United States by entering into this agreement? Did you understand?
Yes, ma'am.
In each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived her right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the cause numbers, in one, your fine is $2,000. The other is $1,500. The cases will run concurrently. And there is to be a recommendation of deferred adjudication, and there's to be restitution to the Bexar County Sheriff's Office for drug testing. Did you understand that to be the plea in each of these cause numbers?
Yes, ma'am.
Defense,
Yes, Your Honor.
state.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
So, Your Honor.
Outside the agreement in the drug case, the state is requesting that your term be for 6 years. There'll be a TAP evaluation, 200 hours community service restitution, parenting classes. In the state jail felony cases, the state is requesting that your community supervision be for 2 years, 100 hours community service restitution, no contact with Layla Aguirre, parenting classes, TAP evaluation, and follow all recommendations in the MRT. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations?
Yes, ma'am.
All right, then, and
There's a minor gun arm that was done, I guess, after here from the paperwork. As far as the no contact, where the agreement is now, because this was, I guess, continued from the last setting for CPS record purposes, for us to do other than and determine what happened at the CPS hearing. So to make it easy, we are agreeing with defense that she can't have contact with the children, but there just be monthly field visits for the entire 2 years of the perjury cases. So
how did y'all ask probation if they want to do monthly field visits?
I did, and it was indicated to me that that would be something they could.
All right. So they're asking then for no harmful or injurious contact with Layla Aguirre. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations? All right, then in cause number 2025 CR 0056, I'm sorry, 7526B, how do you plead to count two?
No contest.
And cause number 2025 CR 009816, how do you plead?
No contest.
State any evidence.
Regarding both cases, Your Honor, state off within the evidence case, there's one of those evidence.
No objection.
And each of the cause numbers, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes.
And each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. And each cause number, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication in each of the cause numbers. So when is the co-defendant scheduled in this case for sentencing?
Tomorrow.
For The other one, for some of this one, we got reset for a week, she was still.
No, I mean, the one that, so this is a case where Suzanne Kramer is the defense attorney
That one's.
tomorrow.
tomorrow. All right, counsel, are you able to come back tomorrow?
I can, Judge. What happened, if the court recalls, originally I wanted it for that same day.
Mhm.
But, guess it wasn't possible when we reset it.
Okay.
But, if I need to come back, Judge, I'll come back.
All right, if y'all can come back, and what I can tell you, this is what I'm going to request. See if the CPS caseworker can zoom in, so the court can see what's going on.
I think the state can
Have the
make a profit, Judge, if they completed everything.
Here's the thing, in some situations, I don't like proffers, because people need to be on the record for what they have done.
Oh,
So,
See if we can get the CPS.
all right, and they can appear by Zoom.
okay, that's fine.
All right, so we'll bring you back tomorrow for sentencing, and
Okay.
sentencing will happen on that day. All right?
Okay.
Once
Thank
you
you.
sign the reset form, you're excused.
Thank you.
You're welcome.
Kelly Aguerrero walked into court facing 2 serious felony charges that put both her freedom and her future on the line. The first was placing a child in imminent danger of physical and mental impairment by allowing the child access to illegal substances, a state jail felony carrying up to 2 years behind bars. The second was even more severe, possession of a controlled substance, penalty group 2, between 4 and 400 grams, a second-degree felony punishable by 2 to 20 years in prison. At the start of the hearing, Judge Stephanie Boyd carefully confirmed that Aguerrero understood every constitutional right she was giving up. She waived indictment in one case, accepted the formal charges, acknowledged the possible prison sentences, and confirmed that no one had threatened or pressured her into accepting the plea agreement. The plea bargain called for deferred adjudication, meaning the judge would postpone a finding of guilt while placing Aguerrero under strict community supervision. The agreement also included thousands of dollars in fines, restitution, parenting classes, community service, drug treatment evaluations, and intensive probation conditions. Judge Boyd made it crystal clear that if Aguerrero violated those conditions, the court could revoke the deferred adjudication and impose the full prison sentences allowed by law. One issue immediately caught the court's attention: the safety of the children. Prosecutors requested restrictions on contact with one child, while defense attorneys explained that Child Protective Services had already established supervision requirements. After discussion, the parties agreed that Aguerrero could have contact with her children only under strict monitoring, including monthly probation field visits and compliance with CPS requirements. After reviewing the written evidence, police reports, and witness statements, Judge Boyd found there was sufficient evidence to support both charges. However, instead of sentencing immediately, she postponed the final decision until the following day. The judge ordered CPS officials to appear by Zoom so the court could hear directly about the family situation before deciding whether Aguerrero deserved the opportunity for deferred adjudication or a harsher sentence.